And as soon as people, yeah, you can start.
Yeah. Is that okay right now?
Yes.
Good. Okay, since it's 3 o'clock right now, so I'll suggest that we can start the webinar conference. So dear speakers and participants, welcome to the LAWASIA Human Rights Webinar, Business and Human Rights During COVID-19, which is a third webinar of LAWASIA Human Rights Committee. My name is Angela Lin, and I am an EXCO member from the Taiwan Bar Association. Today, we are very pleased to have 7 eminent speakers from Germany, Singapore, Japan, Australia, South Korea, China, and India to share their view and experience in their respective jurisdictions. So before we start the webinar conference, just allow me to make some reminder for the webinar conference. All the participants' profiles and video will not show up on the screen, but please to mute your phone during the conference. And also for the speakers, please also mute your phone if you are not making a presentation. And I will like to now have 2 minutes to share the Taiwan experience during this extraordinary timing. I think Taiwan is very lucky that we are doing a comparatively good job in controlling the epidemic. So as of today, we have 445 confirmed cases, and most of the patients have been discharged. So therefore, actually people in Taiwan do not, I believe, do not sense many issues with regard to the restriction or even human rights issues. But I think people in other jurisdictions may have very different experience. So now I would like to invite our first speaker, Dr. Wessels from the German Federal Bar. Dr. Wessels is the president of German Federal Bar. And also allow me to apologize that I would not be able to have the time to introduce the background of each speaker. But our dear participants, you can find the detailed background information of each of the speaker on the LAWASIA website. So now, Dr. Wessels, you have the floor.
Thank you. Thank you very much, and a very warm welcome from Germany. Dear colleagues and friends, as you know, I'm the president of the German Federal Bar. And first of all, I would like to thank LAWASIA for organizing a webinar series and thereby creating a platform for exchange on this important topic. And to thank you also for letting the German Federal Bar be part of this discussion, although we are not exactly a LAWASIA jurisdiction being based here in Europe. So in Germany, as in many other countries worldwide, different infection control measures have been implemented, and the German government opted for developing a contact tracking app. This app is currently being developed by the renowned German software group SAP and telecommunication company Telekom. The idea of implementing a contact tracking app first came up in March, right after the outbreak of the virus in Germany. According to the German government plans, the data collected by the app was supposed to be stored centrally. That's most important because we had a lot of discussions on the centrally stored data. It was also discussed whether a mandatory usage requirement should be introduced. The German Federal Bar took a closer look at the planned measure. The result of our examination showed that the planned phone tracking app not only violated data protection regulations with regard to the centralized data storage, but that the app would also have a particularly substantial impact on people who may only be potentially infected. The German police and emergency response laws and regulations set out very strict requirements with regard to the permissibility of mobile tracking and digital surveillance of individuals. The hurdles that have to be overcome before ordering measures against so-called potential disturbers, the category of individuals which potentially infected persons belong to according to German law, are relatively high. Our examination came to the conclusion that if the tracking of individuals were done without their knowledge and consent, the tracking app would restrict in an inadmissible manner the individual right to decide on the disclosure and usage of personal data. It could also affect the right to the protection of privacy in telecommunications. During our examination, we also found that a mandatory usage requirement does not comply with German law. We issued a legal statement to the Ministry of Justice and Consumer Protection with our findings. Of course, everything that is necessary to protect human life must be done. We also emphasized that we are currently facing an unprecedented crisis situation and that it is in the nature of things that in such an exceptional situation, the fundamental rights of the population are being restricted for the greater good of public health and security. Nevertheless, minimum guarantees under the rule of law must be maintained. Currently, the German government is proposing a new version of the application. It is planned to make it available in mid-June, and that means today. The app started today. The tracking app is now supposed to measure the distance between individuals on the basis of a so-called Bluetooth low energy technology and enables your own smartphone to remember your contacts anonymously. Furthermore, the government opted a data protection friendly, decentralized approach to data storage. Both functions counteract the individual traceability, which is important for compliance with the requirements set out by the German data protection regulation. Furthermore, the German government also followed our demand that the use of the app by the population must be absolutely voluntary. So in the end, and that's our conclusion, our initiative was successful. And it is important that we as lawyers must voice our possible concerns as early as possible, as we have done it. And that's our duty, and we are very glad that we have been successful. Thank you very much.
Thank you very much, Dr. Wessels, to share the very valuable experience, and you're a great time controller. So now I would like you to welcome our second speaker, who is Mr. Eugene Churaisingen from Singapore. Eugene, now the floor is yours.
Thank you. What I will be speaking about is Singapore's legislative approach to the COVID-19 crisis. As our first speaker has highlighted, we are in desperate times, and desperate measures and laws are sometimes critical. In times of crisis, there are typically two options available to governments. First, to declare a state of emergency and have recourse to constitutional emergency powers. Under Singapore law, this power exists under Article 150 of the Constitution. So on the one hand, the state can declare a state of emergency. On the other hand, it can have a more targeted legislative approach that is not declare a state of emergency, but to enact temporary laws directed at addressing the specific issues at hand. Singapore has adopted for the second approach, that is a legislative approach, and temporary laws have been enacted. There are two broad concerns when you talk about emergency lawmaking. First, usually laws under the Westminster system, which Singapore Parliament follows, laws are read in Parliament, they are debated, and studies are undertaken, and they are eventually passed. In these times, there isn't the luxury of time, and it's a very rushed process where these laws were passed and come into force. So there was less time to debate and deliberate over the societal consequences of such legislation, which not only can lead to bad law being made, but also for society not being clear and not being prepared on their obligations under the new law. The second concern that arises is that temporary laws can often become permanent in the long run. For example, we've seen in the US, you have the US Patriot Act. That was the act passed in response to the September 11 attacks. 6 weeks after September 11, the US Congress passed the Patriot Act, which gave the government unprecedented power to spy on American citizens. Some provisions in the Patriot Act were given an expiry date, but many of them eventually became permanent. In Singapore's history, in 1955, the Singapore government passed the Singapore Criminal Law Temporary Provisions Act. That was an act to deal with threats posed by secret societies and criminal syndicates. It allows for detention without trial. Up till today, the CLTPA, the so-called Criminal Temporary Provisions Act, is still in force. Broadly speaking, this time the Singapore government passed the COVID-19 Temporary Measures Act and the COVID-19 Temporary Measures Regulations. This gave the government powers to issue control orders to prevent the spread of COVID-19. It basically gives the minister powers to make control orders. There are some safeguards. The minister must first be satisfied that incidents and transmission of COVID-19 in the community in Singapore constitutes a serious threat to public health. And two, that the control order is necessary or expedient to supplement the Infectious Diseases Act and other written law. The range of control orders issued may entail requiring specific people to stay at or in a place and not leave that place, to restrict movement and contact between people, to require premises or facilities to be closed or subject to limited access, and to prohibit or restrict the participation of people in events and gatherings. There were quite a number of enforcement action and criminal prosecutions under the new laws. Some say it was because of the rushed nature of the laws. Laws came into place. People did not quite understand them. People were sometimes not aware of these laws, not aware of the specifics. So these laws were passed on 7 April. By 18 April, that is just 11 days later, almost 200 people had been fined for breaching safe distancing rules, and over 80 people for not wearing masks. 170 people were, by 23rd April, that is a week later, 170 people were fined for not complying with safe distancing rules, and at least 29 people had been charged in court. Apart from the rushed legislative process, there are also concerns as to whether some of these orders are justified or not. Some academics have weighed in particular, a Singapore constitutional law professor, Ms. Jacqueline Neo, has pointed out that the Singapore government's approach seems justified under the circumstances, and taken at face value, the new laws do not seem to have wide scope for abuse. That is the end of my presentation. Thank you.
Thank you very much, Eugene. I apologize that I didn't introduce Eugene. Is now a partner of Eugene to Racingen LLP at Singapore. And now I think let's welcome our third speaker, who is Ms. Akiko Sato, an attorney at law from Japan. Akiko.
Thank you. Thank you for your introduction. So good afternoon, everybody, or maybe the good evening or the good morning. So thanks to the organizer for having me here. It's my great pleasure to join this webinar with distinguished panelists. So as actually the tracing app, there has not been implemented yet in Japan. Let me begin with sharing the latest situation on business and human rights. So Japanese government that has developed NAP since 2018, and now we have the first draft released in February for public comment. So initially, it was supposed to be finalized around this month. However, due to COVID-19, the process has been suspended. For the NAP process, the working group and the advisory committee were established by the government to discuss its content. The working group comprised of diverse stakeholders, including Keidanren, the largest business foundation in Japan, SME representative, CSO, trade union, and bar association. So in addition to these stakeholders groups, relevant ministries have joined the NAP process as well. So on the basis of the discussion, the first NAP draft described some cross-cutting issues such as labor, child rights protection and promotion, human rights accompanied with development of new technology, consumers' rights and law, equality under the law, receiving foreign workers in inclusive society. Then it states initiative to be taken by the government for state duty to protect human rights as well as those for corporate responsibility to respect human rights, and initiative for access to remedy. So based on such circumstance, it is expected that Japanese National Action Plan on Business and Human Rights, that I called NAP, that could be the first NAP after we experienced the devastating influence of COVID-19. Therefore, we stakeholders think it is really crucial to reflect what has been exposed under the current situation to our NAP being formulated. So in addition to the official meeting we had, the stakeholders have held our own meetings for further discussion. As a result, we submitted 2 letters of request to the government to show our common interest, which needed to be addressed in the NAP. These letters are actually available in English on the website of ILO Tokyo office, so please have a look at them. In the second letter of the request, which was submitted 2 weeks ago, we pointed out the importance of incorporating increasing effect by COVID-19 into the NAP, with reconfirmation of our request in the first letter. With respect to COVID-19, we indicated some major impacts found out, such as increased unemployment, harsh working conditions, discriminatory treatment of non-regular and foreign workers, and so on and so forth. How to respond to these negative impacts is really vital from business and the human rights perspective. Also, when it comes to its implementation, monitoring, and update of NAP, we highlighted that we need to have some tangible measurements of development. So apart from the activities for NAP itself, I'd like to take this opportunity to share some initiatives that I'm involved in dealing with the COVID-19. So Business and Human Rights the Lawyers Network Japan, which is the research group comprising of mostly lawyers, of which I'm a member, has been carrying out the COVID-19 and Business and Human Rights project. The first, we published the report on COVID-19 and Business and Human Rights. The report analysis and impact of the COVID-19 pandemic on human rights related to Japanese business activities and provide guidance for Japanese business to how to respond to it, both in Japan and overseas. The report aims to provide the useful information for Japanese companies, governments, and other stakeholders in considering their responses. In our report, we identified 6 areas of particular concern, namely supply chain, migrant workers, non-regular employment, gig workers and informal sectors, healthcare workers, children, older persons, women, persons with disabilities, and privacy. As I said, the government there has not yet implemented the tracing app, but actually it is likely to be launched shortly. So how to ensure the fundamental human rights are protected is an essential part there to be for argument. So following that, we recently released the COVID-19 and business and human rights basic actions for promoting innovative and responsible business conduct for building back better from COVID-19 crisis. It contains the 10 concrete actions which companies are expected to implement. These are also available on our website. So I hope that they can be useful for you in dealing with the business and human rights issues. We found that Japanese companies and investors have become aware of how important this area is in seeking for recovery, but do not have clear idea how to begin. So to fill that gap, we also hold a number of webinars with relevant actors such as NGO, PLI, Global Company Network Japan, and international organizations. So relevant stakeholders need to work to the same direction for gaining this momentum. Investors like PLI are quite proactive for engagement with companies on human rights issues in relation to the COVID-19, which is, I think, a good sign to ensure the harmonization between the ESG and the business and the human rights. Since we do not have any specific legislation on business and human rights at this moment in Japan, like the one in the UK, France, or Australia, comprehensive viewpoint on how business and human rights can be embedded into daily business decision is crucial, but at the same time, it's still very challenging. So the impact of COVID-19 has been extended globally. So therefore, I believe the partnership among multi-stakeholders and meaningful dialogue with the affected are the significant keys for achieving responsible business while tackling the COVID-19. Thank you for your attention.
Thank you very much, Akiko. Now we will welcome our fourth speaker, Mr. Hubert Algie, who is a planning and environmental lawyer at Calhurst, Australia. So Hubert, you now have the floor.
Thanks, Angela, and thank you to all the other speakers and the attendees. I echo their statements about how good a platform this is. So as was mentioned, I'm an environmental lawyer, so I can't speak to the details of Australia's COVID tracking app, but what I intended to do was tell you a little bit about some of the environmental responses to COVID and the opportunities and the lessons that can be taken from COVID and how they might apply to the climate change movement. The response to COVID has provided us with an opportunity to both undertake additional studies and assessments to understand some of the kind of unanswered questions in the climate change movement. Example is with the lockdown of our major cities, we're seeing a number of studies being able to identify the causal links between some of the localized pollution issues. So an example is in New Delhi, and the pollution problems within New Delhi are being able to be assessed and studied because of the lockdown, and because large parts of the economy are shut down. Greater assessment can be undertaken that shows sort of where pollution is coming from and answer some of those questions which, but for the lockdown of some of our cities, wouldn't be happening. So we're able to use COVID to answer some of these questions, or to start to answer some of the questions around causation of climate change and pollution. We're also seeing throughout the COVID crisis that we're seeing the climate rebound in some instances. So, we've all probably seen through the media examples like Venice and in North America, animals returning to otherwise heavily populated spaces. So we're seeing that that there is strength within the environmental space to rebound. So within the environmental space, we certainly see the lessons from COVID, and that COVID presents an opportunity. It shows us potentially a roadmap for achieving some of the goals to respond to climate change, and it provides potentially a platform that could be built upon. And I think I know currently the UN is meeting to talk about climate change, and I know that a number of businesses, that it's a business meeting within the UN, and their focus is on climate change and how businesses need to be responding to climate change. And the economics are there, both in a more sustainable business model, but also the human rights need. And I think we're seeing that we see how through COVID, how fragile the globe is, and if we don't act globally on issues like human health and the environment, we face the risk of further and more troubling times ahead. Thanks.
Good, thank you very much, Hoover. Although I think your presentation simply presents a different perspective from all other speakers, which actually is quite interesting. So now let's welcome our fifth speaker, who's Miss June Lee. Miss Lee is an attorney of liberty law of South Korea. So June, you have the floor. You have to unmute yourself.
All right. Hi, hello. This is June Lee. I'm very honored to present to you the current situation in Korea. And there was a current social guideline for the COVID-19 by the 21 human rights group associations recently. And they provide a very insightful guidelines for every sector that impacted by the COVID-19. And I wanted to focus on the information human rights, as well as the quarantine and detention and tracing method that can be regarded as almost like a detention and surveillance of the patient. First of all, urgency shall not be the ground to justify discrimination. And unfortunately, there were two largest group pandemic crises happened in Korea. One was happened in Daegu, which was actually group contamination by the religious minority group called the Shincheonji, and all the society members pointed fingers at the religious minority groups because they were the source of the group, contamination. So that was the really crisis, and people were really serious about tracing their movement because it was very big gathering. So they traveled all over the country. So the government had to trace their movement because they are not willing to cooperate with the government unless they cannot trace by the technological devices. So I was surprised to find that three-party cooperation can be very effective, such as credit card use, transportation use can be provided from the credit card company, as well as the CCTV monitoring surveillance system can be very effective. And also there was a kind of a police cooperation to provide spotting location. And the three party cooperated was like telecommunication company, police, and credit card company. Three parties were very effectively locating the potential, patients' movement tracing. So within 10 minutes, they can trace the patient's movement. So it was really scary at the same time. So anyway, it can be, very effective way to control the further contamination, but it can be the very serious threat to the ones who are not willing to expose their privacy too much to the government. So there was kind of awareness, social awareness, that it can be infringement of Personal Information Privacy Act. In the meantime, there's a legal ground under the Prevention of Pandemic Act, which is very much widely accepted in Korea to prevent, to introduce administrative measures to detect and detain potential patients. So there was a kind of public awareness that it can be misused too much. So the social groups require there should.
Please unmute yourself. You've put the mute button. June? June?
In the ground, there's a kind of excessive information was exposed to public, such as the patient's age or job or where they live or where they work. So everyone can, guess where what they did or what they were, playing. So it was like an infringement of privacy too much of the patient. So there should be more detailed guidelines to give balance between the privacy as well as the public health. So it was a very serious challenge in Korean society. The human rights group requested there shall not be the disclosure of the movement of patient itself, but only for the data of the patient shall be disclosed. So that was the guideline suggested from the human rights group. And there was also the second round of pandemic, which is happened at gay club in Itaewon. And also there are, sexually minority groups, and people give hate speeches and, scapegoating on the sexual minority group happened. And it was a very tragic, and people were kind of, worrying about being terminated from the workplace, while if they were known as sexual minority groups or belong to religious minority groups. So the workplace can fire employee based on not following social distancing guidelines, actually established by the workplaces, and the company can legislate and execute the social distancing guidelines as well as government. So they were exposed to termination from the workplace. So it is a very serious situation here, and they were exposed to the double social stamping, termination from the workplace as well as social stamping. And even though they are just being contaminated and they are patient, so it's a kind of very unpleasant reality in here. And there was a information guideline for not revealing too much detailed information of patient, but there is no clear, guidelines for resolving the personal information as well as privacy and the anti-pandemic regulations. That's it.
Thank you very much. I think the South Korean experience is a comparatively stringent policy. I think it shows a quite different policy aspect from what we heard for the previous jurisdictions. So now let's welcome our sixth speaker, Professor Mo Jin-hong. Professor Mo is a constitutional professor from the Institute of International Law, Chinese Academy of Social Sciences from China. So welcome, Professor Mo. You have the floor right now.
Hello. Yeah, dear moderator, most Angela Yeling, yeah, and all the speaker and the participants. Yeah, good afternoon. So I'm Professor Mo Ji-hong, Director of the Institute of International Law. Also, I'm Honorable President of International Association of Constitutional Law. So it's a good opportunity to see you. But I should express my pity because just on June 2, and because my computer didn't work, so I lost opportunity, a chance to have my first speech. So this time I just ask the computer expert to help me. So now I can just have a speech. So I try to express the main viewpoint in the 6 minutes. I try to introduce the two speech. The first is, I think, and maybe I just, before today's presentation, I read the list of the questions asked by the participant. There are many questions. But I think, the COVID-19, this the virus, just concerning many questions, and the legal issue, and the human rights, and the government, the governance, and many questions. But I think the key points, the key issue, I'm a constitutionalist. I think, first of all, and we should have the correct, the legal attitude to the COVID-19, and also we should process and the legal, the correct, the constitutional philosophy, and then we can analyze all kinds of the complicated phenomena very correctly. So here, the first opinion for me, I just think, I have some philosophical idea. The virus is the most impartial judge. So in my first speech, and I analyze the nature of the virus, and then I have my opinion. So just like the human, the virus are creation of the nature. And when the human have not yet understood the mechanism and existence of the virus, maybe the impact, the influence of the virus on the human is negative and harmful. So when the human can recognize the rulers and the mechanism of the virus, the harm of the virus is not so terrible. So even the virus should have their rights just like the human. So so maybe the virus can be used by the human to defeat some certain inborn disease that the human possess. So I should say the virus now at present a human enemy, the common enemy in general, because now we didn't know anything about the virus ruler and existing the mechanism. So if we find a way to analyze, to recognize the ruler of the mechanism of virus, maybe, and we can just turning the wrong thing, a bad thing, into the good things. So here is the legal attitude, and I think the virus, how can we have a correct legal attitude to the virus? So this is the key issue, key viewpoints in such the first the speech. The second, just for today, the speech just a conditional protection of the digital rights. So the digital rights, I think, is a popular conception in contemporary China. So, and my opinion, just the digital rights is very important, maybe in the coming future. But now there are some space very vulgar, not unclear the space for us to identify the meaning of the digital rights. Because if we talk about the rationality of some of the rights, first of all, and we should ask, how can we set up the government's responsibility in the Constitution? If the government can't take the responsibility to protect some the basic rights, so such the rights isn't significant. So we can see in this time, just present this time, and while the digital technology and promote the Chinese government and improve the country's governance capacity and the public requirements for the government to protect the basic rights of citizens are also evolving. So now, and the people think, and we should have the, to some existence, we should have the digital rights. So now, maybe not only require the government to use digital technology to enhance the ability to protect the citizens' basic rights, especially just strengthen the government's responsibility for the social, economic, and cultural rights based on the government service, but more importantly, citizen rights to directly enjoy the fruit of the digital technology development. So, and we can see now and the public and the people discuss about the digital rights because just through this just the COVID-19 and the government take the many digital technology to prevent the COVID-19, and the Chinese government has achieved some success, some degree. So here and we can consider and maybe we can encourage the government to improve the ability by using the digital technology and to protect the people's rights. And then we can just find maybe the citizen and the public and can ask the government to protect and their maybe social, economic, and cultural rights just on basis of the digital technology. And then I'm a constitutionalist, and how can we create the new basic rights? And because we can find the government can have such ability to protect and the people's the legal interest, and also here. And I think the digital rights we can discuss. Maybe we can insert such a digital rights into the constitutional text, maybe in the coming future. And with the development of the government's ability in using the digital technology, maybe the digital rights can become the basic rights protected by the constitutional law. So this is the key viewpoint, just in the second speech. So I don't have enough time, so I just summarize my opinion. So I think this time, and we have acquired the many experience in preventing and controlling COVID-19. And here, and we can find it's very important for us. The first important thing for us to prevent and control COVID-19 is a legal attitude. And we should have correct and the constitutional philosophy if we don't have the correct the idea, so maybe we can't just respond to the COVID-19 correctly. So this is my view, main viewpoint. Thank you.
Thank you very much, Professor Ma. I think now it's time for our last speaker, Dr. Laleen Bhasin. Dr. Bhasin is the president of Bar Association of India. And I understand that Dr. Bhasin just finished a very exciting court hearing and make his best efforts to join this webinar. So Dr. Bhasin, you now have the floor.
Hello, Angela, can you hear me?
Yes, quite clear.
Can you hear me?
Yes, quite clear.
Yeah. Oh, very good. Thanks a lot. You have been an excellent moderator, and I bring to you greetings, from the Bar Association of India, which, India, as you know, is has got the largest population of lawyers in the world. So this greeting is quite meaningful to all the participants. I think it's a brilliant initiative by the LAWASIA Human Rights Committee to take up these very topical and important issues, particularly concerning the digital rights and the contact tracing. I find myself in the distinguished company of such worthy speakers from Germany, from Taiwan, Singapore, Australia, South Korea, and China. In India, the contact tracing app is called the Arogya Setu. It is a controversial step taken by the government. It enables, the government to introduce the contact tracing app so far as the COVID-19 is concerned. It is having a largest user base in the world, over 114 million users of the Arogya Setu. The app has now become open source. It was not in the beginning, as declared by the government on May 26 this year. Now its source code, design, and functions can be publicly tested, and alterations may be proposed. The data collected and processed by Arogya Setu is governed by the app's privacy policy and a protocol released on May 11 by an empowered group constituted under the National Disaster Management Act. The protocol mandates that the data collected can only be shared with the central and state government departments, ministries, and health institutions in anonymized form and strictly for the purpose of formulating or implementing a health response. If required for this purpose, the data can be shared with third parties, including research institutions, subject to the restrictions which are there in the protocol. Legal experts have questioned the authority of an executive empowered group to issue directions which potentially impede upon the fundamental right of privacy of the citizens without a specific and explicit parliamentary legislation on the subject. A framework is proposed under the Personal Data Protection Bill of 2019, which is yet to be enacted. It is still in the formulation stage. At the same time, collection of GPS location data through Arogya Setu has been termed as a surveillance tool and inconsistent with data minimization practices. Managing the tussle between individuals' privacy and public health during a pandemic requires a tough balance. The government's decision to make Arogya Setu voluntary, open source, and subject to public scrutiny are encouraging steps. Nevertheless, the government's responsibility and liability in case of a data breach remains uncertain. So that is, you see, the view from India so far as the Arogya Setu is concerned. So thanks for giving me this opportunity of sharing with the distinguished participants that what is the app applicable in India. Thank you, Angela.
Thank you very much, Dr. Basin. Now, I think we still have 10 minutes. Thank you very much for your great time controlling skills for all the speakers. So now we still have time, 10 minutes left for the QA session. And I think all the speakers, you can see from the screen, the QA bar, there's at least, I think, one question left, and specifically for June. Maybe, so June, can you see that question, and would you like to take the time to respond to that? You have to unmute yourself, yes.
Yeah. I cannot see the questions. Well, okay. All right. Okay.
If you like, Angela, there was another question there that I answered on the the portal that I'm happy to talk to, and that allows a little bit of time for to consider the question, if that suits.
All right. I found the questions, and there is a Personal Information Protection Act in general that allows the freedom of privacy, as well as protecting citizens' right from excessive controlling and management from the government about their information. And it's a very much strict law. And even there is revision of a Personal Information Privacy Act to strengthen the individual's right to decide how to disclose their information. Is based on EU's GDPR, and it's very much globalized standard. However, the problem is that it's a conflicting situation of the Pandemic Prevention Act, which is very broadly legislated measures like to detect patients' movement, or to take municipal governments' administrative measures to prevent public gatherings in certain area or certain time. So it is very broadly regulated measures can be introduced based on the anti-pandemic regulations, which is very much necessary in this time of crisis. However, it still gives questions to how to control citizens' privacy to balance. So that is the current situation here, and the human rights organization in Korea are having a great concerns on this kind of crisis and the conflicting situation. So they published the guideline that I explained earlier.
Thank you, June. So Hubert, we want to make some supplemental comments?
Look, I was just trying to. I have answered one of the questions in the chat there, and I thought I could talk to that to give everybody a bit of time to read the other questions. But the question was from Dev in Nepal, and he talks about, well, how do we, given the impact of COVID and all the tracing apps and all the restrictions, given those impacts to business, how do we encourage businesses to be more socially and kind of responsive into the future. He refers to the corporate social responsibility objectives of the UN and so on. And you know, given the difficulty of business, how do we get business to improve as a response to COVID? And I think, I guess my answer to that was that in many ways this crisis and its impact on business gives us a unique window into what a future will look like if we don't take more drastic action on other areas like climate change or human rights. You know, I think that we are seeing more and more that the world is interconnected, that we cannot be sort of willfully blind to issues of human rights abuses around the world, because they are connected and intertwined with sort of our economic models and the ways in which businesses and governments maybe aren't being socially responsible or environmentally responsible. So I think it presents an opportunity for us as lawyers to be advocating to government and to businesses to say, now's an opportunity to change the way we operate, and being more socially and environmentally responsible will only make you a more viable business into the future. And we should equally be encouraging governments to support and to supplement those businesses that are taking that risk to adapt and to be different in that time. So I think.
Okay, great. Thank you. Thank you very much, Huber. I see a very interesting question from Simon Davis, the president of the Law Society of England and Wales. Although that question was addressed to all the panel members, but I think I would like to specifically would like to have Dr. Vessels and Dr. Basing, if you are still online, to share your view on this question, which is, do you think your government will take any permanent measures to reduce the risk of future pandemic, which may of course impact on human rights? So perhaps Dr. Vessels first.
Okay, thank you very much. It's a pleasure to answer the question of Simon. Well, I think we have to be very suspicious that we don't undermine our parliamentary system and the legislation, so that every law that is made during the epidemic situation has an expiring date, and it's very problematic if we have measures for the future for any pandemic situation, and we can't control effectively if the human rights and the constitutional rights are still in order. And I think therefore we have to be very careful if we have parliamentary engagements and laws that try to prevent a pandemic situation in the future, and does not look at the constitutional rights of the individuals. So I think we have to be careful and have to look at our parliamentary system, that we don't take action for the future which are hitting our constitutional and human rights. And on this basis, I can tell you that in Germany we have a lot of cases at the administrative courts and also at the constitutional court in Germany concerning the human rights and dealing with the question whether human rights are concerned by the restrictions which are done during the pandemic situation. Thank you very much.
Thank you very much, Dr. Vessels. Dr. Basing. Dr. Basing, you have to unmute yourself. Thank you.
I say one learns by one's mistakes. So it is an admission that the Indian government has to learn a lesson so far as any future, God forbid, pandemic you see takes place. Effective steps can be taken within the framework of the existing law, but that has not happened so far as this pandemic is concerned. Possibly the government can say it was not prepared to meet such a huge, colossal calamity in the form of COVID. But I think for future, the message is very clear. Even I will link it up with the question which is there about whether Indian Supreme Court has done enough for the migrant workers, because they are the most affected party, you see, in this pandemic in India. Millions of migrant workers, they had to leave their place of work to go to their homes, and nothing was provided, you see, either by the government or any relief was given by the court. I think both these limbs of the state have failed so far as the migrant workers' plight is concerned. So it is in this context that I am saying that possibly, and God forbid, if this happens again, this could be a lesson for our courts also and for the government also to take care of these poor people, these migrant workers and other poor people whose food has been taken away, shelter has been taken away, no jobs are being given to them. So how will they survive? It's a question of grave violation of human rights, you see, so far as the migrant workers are concerned. And I hope that this will be addressed in case any unfortunate pandemic or epidemic or disaster takes place in future. Thank you.
Thank you very much, Dr. Bhasin. I think I have to take the last question from Sean Deva, who is the co-chairman of the Human Rights Committee of LAWASIA. And I would like to invite all the other three speakers, Akiko, Eugene, and Professor Mo, to answer this question. The question is that do you have any court cases in your jurisdiction where the principle of privacy has been applied by courts to Health Tracing Act situations? So perhaps Akiko first.
Thank you for a great question, but unfortunately, as far as I know, that there is no the court cases in relation to that situation. So as I said, you know, that kind of the app that will be launched soon in Japan. So perhaps in the future we will see how the courts will make a decision on such case. Thank you.
Thank you. So Professor Mo.
Okay, there are some cases, but I don't have enough time to introduce. But I want to express the main viewpoint about the relation between the digital technology and the human rights. Yeah, and I think the digital technology, the changing the traditional structure of rights. So the digital technology aid some of the new rights, but also just limit some traditional rights. So the rights isn't static, but the dynamic. So, but we should insist on the bottom of the human rights protection. Just we should focus on and the core human rights. Maybe this is maybe the right to life, right to health. So here and we should perfect the human rights philosophy. Okay.
Thank you. So Eugene.
There have been no cases in Singapore. Just to pick up on one of the earlier topics discussed, as in whether these laws can be abused. I think the protection that we have in Singapore against the abuse of such laws is that, I mean, even if some of these laws become permanent and allow the minister to make certain orders, we have what is known as judicial review. So if the minister is making use of these laws for improper purpose, not to contain an infectious disease, but for any other purpose, that kind of decision making by the minister can be challenged in the courts.
Okay, great. As we are just a little bit running out of time, I think I would like to maybe just have a stop here. I would like to express our sincere thanks to all the eminent speakers and our participants this afternoon. I believe all of you have enjoyed this presentation as I do. And I also want to remind you that in the future, certainly we do hope things are getting better and better, but in the future, there might be another chances for LAWASIA to launch other conferences through the webinar. So please pay attention to the announcements on the LAWASIA website, and we do want to meet you again for future conferences or webinars. Thank you very much.
Thank you.
Thank you.
Thank
Thank
you.
you.
Thank you, and thank you,
Take care.
Angela.
Thank you, everyone. Thank you.
Thank you.
Thank you.